Welcome, everybody. We got a nice crowd this morning. It's good to see so many familiar faces, but I'm seeing some new faces as well. We have a great panel discussion. Let me do a couple of things here. Today, we have three attorneys from Shulman Rogers. One, I want to thank all of you from Shulman Rogers and your company for supporting NABOE. You've done so for a number of years. I know Lane has been the lead in this, but we've had, I believe it was Don Rogers, Lane, that we had at a NABOE event. And it was terrific. We had him at an event and we were able to lock in a sponsorship shortly thereafter. And it was all thanks to Lane and her efforts. We were talking about the impact of COVID on small businesses. And there's so many legal implications that Lane and I kind of put together some ideas, and then she brought two additional experts, Paul O'Reilly and Joy Einstein. God, Joy, I am really sorry. I'm having trouble with a very simple name, Einstein. To really have a discussion of what would be important for the small business community to understand about COVID and the legal ramifications. So what we're going to do today is let's just have each of you introduce yourselves. Let's start with Joy, go to Paul, and then go to Lane. And just tell us a little bit about yourself, what your role is at Shulman Rogers. And then we come back and I've got a couple questions to start things off.
All right. Hi, everyone. I'm Joy Einstein. I'm a partner in Shulman Rogers Labor and Employment Law Group. We do a little bit of everything in the employment law group. So we do day-to-day employment counseling. My phone rings off the hook all day, every day as issues arise. People call me about FMLA, disability accommodations. They call if they want to fire somebody that day and ask me if it's okay and if I can put together a quick severance package. And then I also do the full range of employment documents that you might need. So employment agreements, offer letters, handbooks. We put on staff trainings, anything and everything contractual we do. And then we have a litigation practice as well. So if companies get sued for paying their people wrong or for discrimination and harassment, or if there is a breach of non-compete or non-solicit issue, we litigate those things. And then sort of unique to our practice that we also have a labor law practice. And so people sometimes ask, what's the difference between labor and employment? Labor just means that you have a unionized workforce. So if you do have a unionized workforce, we help you negotiate collective bargaining agreements, take you through the grievance process, all those things that are unique to labor. I will toss it over to Paul.
So I'm a partner at Shulman Rogers. I'm in the business and real estate section. I have been helping small businesses for the last 30 years. I form companies, I structure them, I help them acquire assets, sell assets, keep them out of trouble. I started as a litigator in the U.S. Attorney's Office. I take that into my business practice so that when we're strategizing on how to move forward with certain aspects of the business, we're always keeping the litigation aspect, what happens if things go wrong. I work with a lot of lenders and do their loan documents. So when our clients are borrowing money, I also review them, help them with negotiating points with their lenders to make sure that they get the best deal before they sign their commitment letter, as opposed to after, when the horse is out of the barn. This year, I've been active with the SBA PPP loans. I've done SBA work for about a decade, and that was a very brisk practice and very frustrating for most of our clients. And so now I'm working with the forgiveness section. And again, another problem with the SBA that a lot of our clients are having with the forgiveness and even just starting the whole process. So as a result, we're very tied into the CARES Act and both Fed and state programs to help our clients keep their doors open.
Very good. Thank you. Lane?
Good morning, everyone, and thank you again for coming and getting up with us. I am a litigation attorney. I basically, I represent people in court, and I help people assess whether or not they should go to court. I have been practicing for over 20 years, and I represent individuals and large businesses and small businesses. And I frankly try to help people also avoid me, because attorneys, most people don't like them, and we're expensive. And if you're in litigation, you're not spending money on your business. You're spending money fighting with somebody that is not helping your bottom line. So I most times try to help people assess, is litigation the only alternative? If it is, I am absolutely willing to help you and will represent you. But if you have other alternatives, you should consider them. And that's a part of what we're going to talk about today, because there are a lot of options for you, not just court. And we're going to talk about that today.
Super. Thank you.
Ron.
Let's I'm jumping around. Maybe I could get my co-host to help when I'm going to start with Joy, and we're going to spotlight the speakers when they speak. Joy, you were mentioning about employment laws, and one of the concerns I have with a lot of our small businesses is that they don't know the laws that are changing. They are, they're being hit hard with COVID, so they're making some quick decisions. One of the reasons I was so excited about having you on is to talk about, I want to make sure they don't get caught up doing some things that's going to get them in trouble. They're going to get them fined or whatever. So could you tell us a little bit about the new employment laws that were impacted by COVID?
Absolutely. So give me 1 second. I want to share my screen with you all.
You are ready to go.
Okay. All right. Can everyone see this? Hopefully.
Yes.
Yes. All right. So first off, I want to hit on the FFCRA, which is the Families First Coronavirus Response Act. Hopefully you all on the line have heard of this act before, because this act has been in place for a couple months now. It's actually set to expire on December 31st if we can't get some new legislation in place, and it's looking dicey on the Hill. I don't know if there's going to be new legislation by the time this expires, but I want to touch on it because, like I said, it expires December 31st. I'm expecting to have a huge crush of employees calling upon this new leave as they travel for Christmas. So my expectation would be that a whole bunch of your staff travel over Christmas. They come back from Christmas with the virus, and then they're asking you for some kind of leave. So this is a new federal law. It applies to basically everybody out there. It applies to, employers with fewer than 500 employees. There is a very narrow exception for employers with fewer than 50 employees. There are certain factors you have to meet to get out of giving this leave to your employees. It basically, you have to say that your business would not be able to remain operational if you were to have to give these leave to employees. So it's a very narrow exception. So really you should talk to counsel if you think you're a small business who might fall under that exception, but otherwise this law is going to apply to you. I should back up and say the FFCRA is broken out into two different types of leaves. So this leave I'm talking about on the first slide here is the expanded FMLA leave. And as I'm going to talk about in the next slides, there is a second type of leave, which is expanded sick leave. So the first is expanded FMLA leave that I'm talking about here. In order to be eligible for this leave, your employees have to be employed for 30 days. And this type of leave applies to people who need to take leave for childcare related reasons. So a school or a daycare has been closed due to COVID-19. I recently got a whole bunch of questions about whether this new type of leave applies to schools that are operating through remote learning. And so the DOL has answered this for us. Your employees are not eligible to take this new leave if they choose remote learning. So some school systems out there are saying you can choose whether to go remote or not. If there's a choice and you choose it, you are disqualified from this leave, but it would apply if your school is fully remote and you have no choice. So duration of leave, again, we're running up on the December 31st deadline. So the good news is your employees can't be asking you for 12 weeks at this point, but 12 weeks is the total. And so if we see that this law gets extended past December 31st through new legislation, that 12 weeks is the time limit. And this time is included in and not in addition to FMLA leave. So for example, I just had a baby. I was out for 3 months on FMLA leave, and I thought, great, now if I get COVID, I'm also going to be able to take this additional leave. That's actually not true. So it runs sort of not concurrently, but you don't get an additional entitlement for this leave if you've already taken other kinds of FMLA during the year. So this leave is paid at least partially. So if your employees ask for this kind of leave for childcare reasons, the first 10 days is unpaid unless they tell you they want to use their emergency paid sick leave, which I'm going to discuss next. And then the remaining 10 weeks of leave would be paid at 2/3 of the employee's regular rate, up to $200 a day. And employers receive a payroll tax credit for this new kind of leave. So it's funded by the federal government in the form of tax credits. And so I know it's difficult for a lot of small businesses to have their employees keep going out on leave during this challenging time period. But at least, if anything, the days they take off are funded by the government. So you can ask your employees for certification that they need to take this type of leave. And, that is a best practice because you want to make sure that your employees aren't inventing reasons to be out and it's sort of a runaway train of all of your employees taking this leave. So things that you are permitted to ask for in terms of a certification: name, dates of leave, a statement of the reason, the COVID-related reason why they're taking leave. And then because this type applies to childcare, they can give you a statement that nobody else is available to take care of their child during this time. Now I'm going to segue on to the second type of leave that the new federal law has granted to employees. So this is the emergency paid sick leave under the new coronavirus law. So the same kinds of employers are covered. So again, like I just discussed on previous slides, it applies to all employers who employ 500 or fewer employees. Again, there's a small business exception that's very narrow. Basically, if granting your employees this kind of leave would cause your business to go under. Employees are eligible for this sick leave immediately. So in the previous slide, I talked about how there's a 30-day waiting period. There is no 30-day waiting period for this emergency sick leave. And employees are permitted to take this leave if they have to quarantine, if they've been advised to self-quarantine, if they're having COVID symptoms and they need to seek medical help, if they're caring for somebody else, a family member who is subject to a quarantine or isolation order, and if they're caring for a child whose school or daycare is closed. So again, the paid sick leave only lasts for 10 days. And this leave also can only be used through December 31st. Although again, I'm watching to see what happens and if we're going to get some additional legislation passed here that would extend this. So what about pay? because nothing is ever simple when the government is involved, they've created a sort of confusing pay structure, but I've tried to break it down simply. If employees take leave for reasons 1 through 3 on the previous slide, leave is paid at the employee's regular rate up to $500 a day. If leave is taken for reasons 4 through 6 on the previous slide, leave is paid at 2/3 of the employee's regular rate up to $200 a day. And again, employers receive a payroll tax credit for this leave, so they don't have to front the cost. I've gotten a whole bunch of questions in my practice about how you calculate the employee's regular rate of pay. It gets complicated when you get into the nitty-gritty. Not every employee out there is paid on an hourly basis. There's some issues involving, how do you calculate employees who are paid on commission? Some employees are paid on a piece rate basis. All of that gets very complicated. And so I don't want to get into it now, but I would say if you do have a particular question about how to calculate how much your employee makes for their regular rate under this law, just feel free to give me a call or send me a chat. It gets a little bit too complicated. Again, if employees need to take emergency paid sick leave, you should be requesting documentation for them, name, dates of leave, the COVID-related reason, and you can ask them for, the name of the government entity ordering the quarantine or their healthcare provider's name. And if they need the sick leave because they're caring for a family member who is sick, you can ask them for that person's name and their relationship to you. So that takes care of the federal law. Now, I know that some of you out there have small businesses in the District of Columbia, and so the District of Columbia has also put in place its own legislation. So DC passed the Coronavirus Support Clarification Emergency Amendment Act. This law temporarily amends the Accrued Sick and Safe Leave Act that DC has in place and DC's Family Medical Leave Act. So long as employees in DC have been there for at least 15 days, they are going to be able to access 2 additional weeks of paid leave for the same reasons as the FFCRA. So employees in DC can take 2 more weeks of paid leave for all the reasons that I discussed on the previous slide. And DC's law applies to employers with 50 to 499 employees. So at least for DC's law, the small employers get a little bit of a break here because it only applies if you have at least 50 employees. The District of Columbia also amended its FMLA leaves. So DC has its own FMLA statute. DC changed its law so that employees can now take up to 16 weeks of leave. This is unpaid leave if they need to be out due to COVID-19. So if they have a recommendation from a doctor that they need to quarantine or isolate, if they're caring for a family member or household member who needs to quarantine or isolate, or if they need to care for children because their daycare or school has closed. So pretty generous leave law in DC as a result of this pandemic. Virginia has taken a little bit of a different tactic. It didn't amend its leave laws, but Virginia passed an emergency temporary standard. And this requires employers in Virginia to take affirmative steps to control, prevent, and mitigate the spread of COVID. So this is a sort of massive undertaking in Virginia, and it sort of remains to be seen how it's going to be enforced and what exactly employers are supposed to be doing. And I would say if you are a Virginia employer and you want more information about this temporary emergency standard, please contact me because it's a lot to bite off and talk about in this very limited presentation. But basically, Virginia wants all employers to assess the level of risk that exists in their workplace and categorize your workplace as high, medium, or low risks of COVID exposure. And according to that kind of classification, they want you to put into place certain return to work protocols, such as distancing, sanitizing, and disinfecting procedures, and what your office's plan is to do with regards to PPE. So again, you are supposed to conduct an assessment and then take affirmative steps after your assessment to make sure your workplace is as safe as it can be. I also wanted to touch upon the WARN Act. And, the WARN Act, it applies to employers with 100 plus employees. And the WARN Act says that you are supposed to provide 60 days advance notice of closings or mass layoffs. So this can be a tricky act during the pandemic because, you're supposed to give employees advance notice, but most employers out there are having to take drastic actions with almost no notice. And so, what my clients have used to sort of get around WARN is this narrow exception for unforeseen business circumstances. So under the WARN Act, there are certain exceptions which would allow you not to provide the 60 days notice. And one of those are natural disasters. And that's sort of what employers have been using in cases where they can't give that much notice because, they've made an emergency decision that they need to make layoffs. So if you're an employer who is contemplating making a whole bunch of layoffs, you definitely need to think about WARN. And I'm going to skip over this slide here and talk about Maryland's MiniWarning. So Maryland, just in October, so interesting timing on this new law in Maryland, passed what's called a MiniWarning. And so now in Maryland, you're also required to give advance notice of certain mass layoffs. This one applies to employers who have at least 50 employees and have been operating in Maryland for a year. So, it greatly expands. Before only the federal WARN Act applied, and federal WARN only applies to larger employees. But now even smaller sized Maryland businesses are going to have to comply with this. This applies to reductions in force of at least 25% or 15 employees over a 3-month period. So that's actually a pretty low bar. 15 employees over a 3-month period means a lot of small businesses impacted by COVID could have to comply with this law. Maryland is still in the process of developing regulations related to this. It's got a little bit bogged down in other more pressing issues that the state has had to deal with. And so we don't anticipate it's going to be fully implemented and enforced until April. But employers in April could still be dealing with layoffs they need to make as a result of COVID. And so this could be a new source of woe and worry for employers in Maryland. How am I doing on time, everyone?
We're running short. We got to get the other two on. So can you wrap in 2 minutes?
Yes.
Okay, good.
So basically, how can employment law help your small business survive the pandemic? This is what I can use to sort of wrap up my presentation. Employment law can help you survive this pandemic. And, just a couple of ideas, that I wanted to throw out to the small business community. Your policies should be working for you. And so what do I mean by that? I've had a lot of clients say to me, I need to cut costs. The business is really struggling. I have had a 100% uptick in the number of clients who have asked me to draft unlimited PTO policies. Why? Because if you have unlimited PTO, it means you don't have to have a whole bunch of accrued unused leave on your books. If you transition to an unlimited policy, there are no more accruals. Employees just take leave as they see fit. And so it obviously doesn't work for every business. It involves a level of trust, between you and your employees. But again, it takes all the accrued leave off your books. And so I do think unlimited PTO is probably the wave of the future. Also because it gives employees the flexible schedules they need to deal with childcare or illness as a result of the pandemic. So that is one thing that my clients have seen help them get through this pandemic. You should, be revamping your telework policies or putting a telework policy in place if you don't have one already. You need to reserve to yourselves the right to, pull any employee off of telework if they're not abiding by the policy appropriately. And that helps with some discipline issues and productivity issues that employers have been running across due to teleworking. You really need to be putting into place timekeeping and overtime policies. Now that people are remote, your hourly workers still need to be keeping track of their time. And, everyone is at greater risk of working overtime since we're sort of just all at home and connected at all hours of the day. So you really do need to have a policy in place regards to overtime so we don't see a wave of litigation related to wage and hour claims. Discrimination and harassment policies need to be revamped. We're anticipating a wave of age discrimination claims. Older workers, have been experiencing discrimination because they're, might not be up to speed on the latest Zoom or Teams meeting technology. And so your policies need to make clear that discrimination on the basis of age or any other basis is not okay. That would help limit your liability in the future. Revamping your leave policies. And then again, I've seen a huge uptick in tuition and course reimbursement policies. This is because employers are asking their employees to learn new skills so they can pivot and survive the pandemic. So employment law is here to help you. There are certain things you can do employment-wise to help survive the pandemic, and those are just some thoughts.
One of the things that I was impressed when we were talking, in preparation for this meeting, is your knowledge of the SBA and what's coming up and what's coming down the pike, and what is still available to support small businesses. So can you tell us a little bit about that as you go into your presentation?
Sure thing, Ron. And I'll also keep my presentation short. I know we're running over, so I've abbreviated as we were going through this. So everyone knows, the PPP program was a disaster for a lot of small businesses. I don't blame the SBA for that. I blame Congress. They pushed it on them. The SBA was not prepared for such an onslaught. They didn't have the staff. They didn't have enough time to forecast to the lenders what they expected, what was going to be an issue for them, and how to move forward. So every lender had its own issues and to deal with the programs, and it led to a lot of frustration. Now, on the back end, we have a lot of frustration now where most of the larger lenders have not opened their portals for the forgiveness program. And now some of them are coming out. I'm talking to a lot of the different lenders. They are not requiring repayment. So a lot of their loan docs started after 6 months, you have to start repaying the loan. So they've informed their borrowers, you don't have to start repaying the loan. We haven't opened our portals. Don't panic. When we open our portals, we'll move as quickly as possible. Some of the banks, I've been talking to officers at the banks, and they're really not sure how they're going to address this. They know it's going to be difficult. They didn't collect all the important data in front. So now they're going to have to figure out who's going to be staffing the forgiveness program. And this is going to be frustrating for most borrowers down the road. So that money has already been spent. I mean, everyone here is viewing, everyone knows, that the money was a stopgap measure. It was only supposed to be really for 2.5 months. And now we're 8-9 months into this. So Congress was trying to pass new PPP legislation. They were looking to early December, but basically last week they were trying to push it. There's been fighting between the House and Senate, big shock there. They've been talking about infusing somewhere between $288 billion to about $330 billion into small business programs. This time they're trying to get it right. most of the small businesses didn't benefit from this. The larger businesses did. If you have following the news, there was a lawsuit where a judge ordered the SBA to release the names of the companies that got loans and how much they received. And you'll see that a lot of the larger corporations, publicly traded companies received a large chunk of that money. And it really didn't help the smaller businesses as it was designed. So going forward, now they're going to look to the Biden administration to get this cleaned up and get it right. Hopefully they will. They're talking about not allowing publicly traded companies to apply for the loan. They're putting on more restrictions with respect to loss of revenue. They may reduce the number of employees who will be eligible. So instead of, no more than 500, they'll go down. Some of the Congress people are talking to no more than 100. I mean, not quite sure where that's going to land. They're also asking for more money to be assessed and open up the EIDL portals so that you can supplement your PPP loan with the EIDL because you need more operational money. So with the PPP, fine, for employees to keep your people in place and to pay some of your operational costs, mostly rent. I mean, it's pretty limited, but they needed more. And the EIDL portals were a mess. The SBA didn't have proper guidance, and they had a lot of temps working for them, and they didn't really know what they were doing. And those who got frustrated gave up. Those who persisted finally got the SBA to give them the loan, but it took weeks and weeks of persistence. So that will be something when the next round, I think it is going to come probably sometime in February. Don't be dissuaded by all the bureaucracy. Just keep pushing and pushing and calling. And like I said, you're going to be dealing, if you're dealing directly on an EIDL, you're going to be dealing with people who have no idea how that structure works. And that's just going to be a problem for you. So try to keep going up the chain to get someone who actually works there. So we will keep you posted. Shulman Rogers has been really good in updating its website regularly with different articles, what's going on with the feds, what's going on, Maryland State, DC, and Virginia, what kind of programs are out there, and how to address your problems. So the employment alerts coming out from Joy and her group, which has been fantastic. My clients have really appreciated that, and it's helped them a lot. Plus, it's kept down their legal bills. So, so they've been very, very pleasantly surprised about that. What can we expect next year under COVID? I think the issue will be how to adjust what's going the new normal, right? So telecommuting is now no longer something that's for large corporations and the federal government. Telecommuting is for everyone. So if you're a small business, make sure that you're prepared for this. So the Biden administration is infusing a lot more money, or they plan to infuse a lot more money into job training, internships that you can, as a small business, tap into, so that you can capitalize on the younger workforce who are much more tech savvy than a lot of people coming up. And if you're a millennial, you're still behind these, the 20-somethings and and the teenagers. So just because of their age, don't discount that. And with the programs, you'll give them a job, and the government will pay for their programs. So that's a helpful thing. You need to watch, and we'll be giving releases along the way as to what Maryland is doing, what DC is doing, what Virginia is doing for the programs. And you really need to be on your toes with that because the money runs out quickly. As you've seen, those who tried to get loans through Maryland, the portals closed within 2 days, and they were foreclosed from accessing it. So they really need to be on it and be prepared for what documents they need and get that going. So with respect to operating your business in COVID, your issue will be how is your technology? Are you able to do the telecommuting If you're not, you need to look for these grants and these low interest loan programs to supplement that, because even after COVID, that's not going away. People are expanding their workforce. They're now hiring people in other areas of the country where labor is less expensive, and they're able to be much more competitive than the smaller businesses who were not able to adjust. Those of you who rely on the workforce for skilled laborers from other countries have been frustrated because of the current administration and their hard line on immigration. So the Biden administration is talking about loosening that issue and opening up the visas for skilled workers to come in, for short periods of time to help you out. So that's going to be a useful program for particularly those people in the technology sector to be able to bring people in, and the science and R&D sector. So that'll be helpful. With respect to shifting business, there's going to be a lot more money coming in the next few years for you to develop your e-commerce business. So those of you who are relying on sales in your sales force, there'll be job training for that, so that now you'll be able to sell better on Zoom, or learn how to network and use your computer systems and use the cloud, and use these webinars to attract more business. So there will be money coming in both on the state and federal level. That's just, I don't expect that probably until next summer. So keep an eye out for that. Keep an eye out on our website for anything that comes up. We will be posting alerts. The other thing that I think you need to watch out for and you need to be prepared for is that the Biden administration has also said that they're going to start increasing the number of federal employees for OSHA, for labor, and that's going to be an issue. Those who are not in compliance with OSHA, they better be in compliance quickly, both federal and state. If you're in DC, they follow the feds. Maryland and Virginia have their own. You get hit with an OSHA violation, that's a fine that could really cripple your business. So some people are just unaware, and then some people are just negligent. So those are things that if you need help with, we can help you with that. If you've already been fined, we can help you with that too. So we've been in there in the administrative offices, both in all three jurisdictions, trying to get these fines reduced. So they're not going to go away, but we certainly can get them reduced. As far as the Department of Labor and putting in people to see what's going on with your workforce, again, I think Joy is going to be pretty busy with FLSA lawsuits because more and more people are going to be scrutinized. And then those of you with who are paying people as independent contractors, you really need to talk to the employment section at Shulman Rogers, because those people you classify as a 1099 may not be actually 1099, and they've already started, and not to the degree that the Biden administration has warned that they're going to start, but Department of Labor and both the Maryland and Virginia governments are looking at the classification because they're looking for revenue.
Lane, this is an easy one for me because I had asked you to come in yesterday to one of my CEO group meetings to discuss a topic that has come up over and over again with some of the firms that have really been hit hard with COVID. And one of their biggest expenses, other than salaries, is their rent. And the question came up is, what happens if I don't pay my rent for my office space? So I'm going to turn it over to you with that question and hear the answer.
Well, I'll give you a typical lawyer response. It depends, right? Anything right now is very fact specific, and it depends upon how the pandemic impacts you. So the first questions I'm going to ask, and when someone comes to me with a question like that, is Well, I need to know about your business. After I run a conflict check, I need to know about your business, and I need to understand kind of how has the pandemic impacted your business? What type of business is it? Is it a customer-facing business or not? Are you a retail shop? Have you been shut down and completely closed by a governmental order? So things like that are going to play into whether or not I can say, hey, you don't need to pay your rent. Or really the first thing I'm going to recommend to anyone is to pick up the phone. Talk to your landlord or to your tenant, depends on what side of the issue you're on, and really come to the table and approach this dispute in a way that results in some type of compromise. Because what I will kind of pivot to talking about is, what are the courts doing right now? Right now, basically everything is pretty much moving at a glacier pace. Everything is very slow. When everything shut down at the end of March and the courts closed, we could file things, but they just sat there. They were not processed. So for many, many months, cases really didn't move. We didn't even get summonses, which are the documents that we use to serve complaints. We didn't get those for several months. Even if we filed in March, we might not see them until the end of July or August. So even cases that have been filed and are starting to move, they're really moving slowly because the court is really trying to get caught up on the many cases that have been filed. So we end up with a situation where people are very upset. They're either not being paid or they can't pay. Someone files suit and we're trying to figure out, what do we do? Well, I can take your money and you can file suit and then it'll sit there for several months and nothing will happen. And as an attorney, I can't always recommend that. I have to say, look, you need to try first every option you have before I file suit. Because once you go that route, it's sometimes hard to pull that back and to kind of put the bullet back in the gun. You can't do that. Once you pull the trigger, it's gone. So but even when that happens, what I'm finding in many different jurisdictions, and I'm licensed in DC and Maryland as well as Hawaii, what I'm finding is that even we file suit, we pursue discovery, we file a motion, the court then looks at us at a status hearing and says, I think you should go to mediation. You've just spent all of this money to file suit, and the court is still saying, I still want you to work it out, because the court is so overwhelmed. They really don't want to deal with trials. Many of the courts right now are not allowing jury trials. They're not allowing large numbers of the public to come into the court to actually hear a jury trial. So if you've demanded a jury trial, your case is going to get pushed way back behind many cases that can be heard by a judge. So if some of you may understand that you can either have a judge decide your case or a jury, a set of people decide your case. And if you've requested a jury trial, you may not have that jury trial for a year or more, even if your case has been pending for many years. So it's what I'm seeing right now is everything is slowed down so much that people who want to extract that pound of flesh are very upset. They're not going to get an immediate result that they want. So I'm trying to encourage my clients to figure out a solution that makes sense and works for both sides. So I'm going to share my screen for a second because I'm going to just talk a little bit about what I am seeing in terms of the main type of cases are breach of contract cases. And really, because what we're dealing with is a finite amount of money. You know, most of you have businesses that as soon as the pandemic hit, if you're retail businesses, you had no foot traffic, all revenues pretty much shut down or stopped, and you really had no money coming in. So what ends up happening is we're fighting over a very finite amount of money. Unless you got a loan, an EIDL loan or a PPP loan, you really started to have to deal with, what am I going to pay? And you're making choices of you're paying rent or you're paying payroll or other expenses. And what the primary case I'm dealing with, and most of it, is breach of contract. And really when something happens, I'm going to ask someone, I need to see your contract. I need to see what it says. And I need to understand, what do you want? In most cases, it is damages. It's really not specific performance. Sometimes it's just trying to get out of the contract. That's also an option. But what I'm dealing with is trying to figure out what's a solution and trying to figure out how to enforce the contract and get money, or prevent another side from enforcing the contract and collecting the money. So you talked about a lease, Ron, and whether or not you should pay rent. When I get a lease, these are pretty much the key provisions I look at when I get a lease to try to figure out What are your options? What are your obligations? What are your deadlines? What are your notice requirements in order to enforce the terms or to ensure the other side has actually complied with notice provisions, for example? What are you supposed to be doing? You're supposed to be continuously operating. If you've been ordered to shut down, can you? Is that even something that the landlord can enforce? It may be something where you're on the tenant side and you're looking at trying to figure out a way to show that the landlord has breached its obligations and not being able to deliver. What is the expectation of the contract, which is to be able to use your space? Why should you pay rent if you can't use your space? But the reality is the landlord's looking at it saying, I didn't shut you down. This isn't through the landlord. This is through the government. So one of the key things we end up looking at are these language or provisions, if you have one, called force majeure or act of God. And these terms are pretty critical if they're in your contract. So I'm always going to look to these terms if you have one. And what does it say? Because this is really a term where the parties have agreed by contract to shift risk. If something occurs that we've contemplated, what will happen? You either will pay rent or you won't. You will abate your rent or you'll still have to pay even if there is a complete shutdown. So this language is pretty critical. If you don't have one, it doesn't necessarily mean you can't rely upon this concept of force majeure. It's really something else. And these are common law concepts called impossibility, impracticability, and frustration of purpose, where we basically look to the common law that says if for some reason your performance has been rendered impossible, then you're able to suspend or terminate your performance. And so just going back to this, the contractual language, you really want to look to what's in it. If you are negotiating a contract right now, it's pretty critical, depending upon what side you're on, that this term addresses pandemic or virus or whatever this is right now. A lot of contracts do not deal with a pandemic or a virus. And some do, but very few do. So this is something that now, as we're rewriting contracts going forward, we are really including something that specifically addresses it so that we know what will happen next time. Hopefully there isn't a next time, but quite frankly, there may be. And I think as a practical matter, it would be irresponsible of us as attorneys not to include this in new contracts going forward. So to answer your question, if somebody came to me in April and said, I have no revenues coming in, what do I do? I would advise someone very differently then as I would now, because now people are able to operate using some percentage occupancy, depending upon what phase you're in and what county your business is located. You can, at a point where you had no use of your space, I might recommend that a tenant not pay rent and use that as leverage to get the landlord to the negotiating table. Now, where you're able to perform, it's harder to argue impossibility. It's just now not more cost effective. And depending upon the jurisdiction you're in, courts are saying just because it's not as profitable for you to perform doesn't necessarily mean that you can't perform. It just means you don't make as much money. And that's a part of when sophisticated business people negotiate contracts, they allocate that risk. And if it's not clear in your contract, it's going to be hard to argue one way or another what should happen. But if it's gray, it's definitely better to be in a position to argue that you don't have to perform, in contrast with having a very clear term that says, no matter what happens, you have to pay your rent. That's a very long answer to your question, Ron.